Hello, everyone. Welcome to Court with Krissy. If you're not paying your child support, here's a tip. Try and look malnourished. I hope you like it. Court with Krissy is now in session.
Case number 19CR35994, the State of Ohio versus Jerry Johnson. Mr. Johnson is before the court with his counsel, Mr. Gibbs. Ms. Belknap is here. My docket says Howard, and I do that a lot. And look at this instead of looking at Ms. Belknap's here on behalf of the CSEA. Mr. Gibbs, does your client wish to have a hearing on these allegations?
In discussions, Your Honor, it's my understanding that he wishes to admit to the allegations of the violation.
Mr. Johnson, you understand that you're entitled to have a hearing, and you wish to waive that hearing and admit to the violation? Okay. The court's going to find that you have violated the terms of your community control. Is this a merger?
Yes.
You're proceeding on count?
Count two.
Mr. Johnson, Mr. Gibbs, is there anything you'd like to say? I know where the state stands, so.
Yes, Your Honor. In discussions with my client, he's very remorseful. He recognizes that, just frankly put, he screwed up and has stated to me, frankly, repeatedly, he'd rather go hungry than not pay child support going forward. He has been filling the role of caretaker for his girlfriend's mother, who has some pretty severe health issues. That was corroborated by his girlfriend reaching out to me as well. He's very motivated and, again, would request the court to permit him to be released so that he could obtain gainful employment and make good on these obligations.
Do we have a jail time credit on this?
Your Honor, according to Officer Henry, the jail time credit is 53 days with 21 days on this violation.
All right. Mr. Johnson, is there something you want to say?
Since I've been incarcerated this time, that's all I did was think. I did write you a letter. I don't know if you received it. And I thought myself to a migraine after migraine. It's not fun. And like I would go hungry and pay child support than not pay child support and eat. You won't see me back again, I promise. If it's $30,000, my number one goal is if you release me today, I will get a job and I'll keep in touch with my PO. And I can't do this anymore. I just want to pay it off as fast as I can get it paid off. I promise you, you will not see me again.
Mr. Johnson, do you have any idea how many times I hear that in a day?
Probably. Yeah.
Honestly, you've had 5 years to get this taken care. Is the arrearage? Has there been any voluntary payments at all from Mr. Johnson?
The last voluntary payment was when he was before the court at the preliminary violation hearing. He paid $100 that day. There was no voluntary payments in the year of 2024 at all.
How is that possible? You just said that you'd rather go hungry and not eat than not pay your child support, but yet here you are, fed and well-nourished, and you haven't paid any child support. How much has he paid over the course of this supervision?
Since he's been on supervision in January of 2020, he paid $7,535.84.
I keep my word, I promise.
I'm sorry?
I'll give you my word, I promise.
You gave me your word 5 years ago. You didn't do it. I don't understand. How all of a sudden now this is a priority?
Because I know y'all mean business. I do.
Sir, I've looked at your prior record. I reviewed it before I came on the bench. I meant business 5 years ago. This wasn't something that was discretionary. I ordered you to do it, and you ignored it. Right? All right. The court is dealing with multiple offenses arising out of the same incident, and the court will find that the 2 counts are allied offenses of similar import. The state electing to proceed on count 1, you will only be sentenced on one of the counts. Count 2, correct?
Count 2.
Okay. Mr. Johnson, the court is going to find today that you are no longer amenable to community control in the prison as necessary to fulfill the purposes and the principles of sentencing, including punishment, deterrence, and protection of the public. The court's going to further find that this is not a technical violation of the terms of your community control, since this is a child support case. I mean, obviously, paying child support is the key component to this. So the court had previously reserved a 12-month sentence. The court is going to order you to serve a 10-month sentence in prison. You'll get credit for the 53 days you've already served. You're also subject to a discretionary period of post-release control. Upon your release from prison, the Adult Parole Authority may supervise you for a period of up to 2 years. If you violate that supervision, you can be returned to prison for up to 1/2 of the court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year, or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. So there may be opportunities for you to receive up to 1 day per month for participating in certain education, vocation, or other programs sponsored by the Department of Corrections. Is there something you want to say?
So you're sending me.
Is there something you want to say?
So you send me to prison? is
I
what
am.
you're saying.
You did not do what I ordered.
For how long?
10 months, minus the 53 days.
So what is gonna happen with my probation in Indiana? I'm gonna be violated down there and go back?
I
to
don't know
prison
anything,
forever?
that's not my jurisdiction, so I don't know the answer to that. All right, there's a deputy standing by. You go with the deputy, please.
All right, Mr. Mulligan.
All right, this is case number 24CR41764, the State of Ohio versus Samuel Brown. Mr. Brown is before the court with his counsel, Mr. Mulligan. Ms. Nicholson is here on behalf of the State of Ohio. Ms. Nicholson?
Your Honor, this is a Judge Peeler case. This was set for plea a couple of weeks ago. Mr. Mulligan had asked that it be continued out to allow his client to get his affairs in order. So we are here for a plea with an agreed sentence. The agreed sentence is a total of 24 months in prison, 12 months on all of the counts that he is pleading guilty to, as well as 12 months on a gun specification to run. Those will run consecutive for the 24 months. He has agreed that he will not request nor be granted judicial release during that time period. The state also dismissed the firearm forfeiture specifications in exchange for the defendant to agree to forfeit the 3 specific firearms that are listed by serial number in the plea form. And additionally, the defendant is pleading guilty to a money forfeiture specification to counts 10 and 11.
All right, Mr. Mulligan, is all that accurate?
It is, Your Honor.
Okay, Mr. Brown, they're telling me you want to change your plea to guilty. Some of these charges are amended charges. Looks like 1, 3, and 5 are amended charges. 6, 10, and 11 are original charges, and there are certain specifications to some of the charges. Before we get to your change of plea, I need to go over some things with you, okay, sir?
Yes, Your Honor.
How old are you?
21.
How far did you go in school?
I graduated high school.
So you can read and write okay.
Yes.
Are you a citizen of the United States?
Yes, sir.
Has anyone promised you how the court would sentence you, other than this recommendation to me that I sentence you according to what this says, which is basically 24 months in prison, no judicial release, forfeiture of the firearms, and forfeiture of the cash?
No, sir.
Has anyone threatened you in any way to get you to plead guilty against your will?
No, sir.
Are you satisfied with the representation you've received from Mr. Mulligan?
Yes, sir.
Are you currently under the influence of any drugs or alcohol?
No.
Do you take any medication that interferes with your ability to understand what's going on today?
No.
I have in front of me a document called a change of plea and entry. On page 3 of this document, on the line marked defendant, there appears a signature. Did you sign this?
Yes, sir.
Did you read this and go over it with your attorney before you signed it?
Yeah.
And you believe you understand what it says?
Yes, sir.
The first count that you're pleading guilty to is aggravated possession of drugs as a felony of the 3rd degree. That carries a maximum penalty of 36 months in prison and a maximum fine of $10,000. $5,000 of that is a mandatory fine. Count 3 is aggravated trafficking in drugs, also a felony of the 3rd degree. That also carries a maximum penalty of 36 months in prison and a maximum fine of $10,000. And again, $5,000 of that fine is mandatory. Count 5 is one of trafficking in hashish. A felony of the 3rd degree also carries a maximum penalty of 36 months in prison and a maximum fine of $10,000. And again, $5,000 of that is a mandatory fine. Count 6 is possession of hashish. A felony of the third degree also carries a maximum penalty of 36 months in prison and a maximum fine of $10,000. $5,000 of that is also considered to be a mandatory fine. Count number 10 is trafficking in marijuana, a felony of the fourth degree. That carries a maximum penalty of 18 months in prison and a maximum fine of $5,000. That carries with it a firearm specification of 1 year in prison, which is mandatory and must be served prior to and before any other sentence is prior to and consecutive to any other sentence the court issues. Do you understand that?
Yes, sir.
All right. That also carries with it a specification for forfeiture of money in a sum of $7,421. And then finally, count 11 is the possession of marijuana as a felony of the fifth degree, and that carries a maximum penalty of 12 months in prison and a maximum fine of $2,500. That also has the firearm specification with it of 1 year and a forfeiture specification for money of $7,421. Is it the state's position that these firearm specifications merge?
Yes, Your Honor. We're dealing with the same firearm, same,
Okay,
yes.
just wanted to make sure, because sometimes they stack.
No, yeah, they merge.
Okay.
That's our position.
So do you understand the maximum and mandatory penalties involved with all of these charges?
Yes, sir.
In addition to those maximum and mandatory penalties, you are also subject to a discretionary period of post-release control, which means upon your release from prison, the adult parole authority may supervise you for a period of up to 2 years. If you violate that supervision, you can be returned to prison for up to 1/2 of the court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever's longer, and that time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes, sir.
Now, you're presumed innocent of these charges. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury. If you want, we will impanel a jury of 12 people and require the state to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or they are required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, sir.
At that trial, you have a right to see and hear all the evidence that the state has against you with the help of your attorney, the right to confront and cross-examine each of the state's witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, sir.
And you have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything else from your silence. Do you understand that?
Yes, sir.
The burden of proof is on the state. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes, sir.
You could also waive your right to a jury trial, but maintain all the other rights we've discussed. You can try your case to the court. Judge Peeler would also have to be convinced of your guilt beyond a reasonable doubt, or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you believe you understand each of these rights we've discussed?
Yes, Your Honor.
Do you understand that when you enter a plea of guilty, you will be waiving all these rights? There will not be a trial.
Yes, sir.
This is how you wish to proceed.
Yes.
All right, Ms. Nichols.
Your Honor, if this case would have proceeded to trial, the state would have proven beyond a reasonable doubt that on or about August 21st of 2023, the defendant sold over the bulk amount of psilocybin and psilocin in the amount of 467.3 grams. That is a Schedule I substance. And that on August 31st of 2023, that the defendant sold, again, over the bulk amount of psilocybin and psilocin in the amount of 492.4 grams, also a Schedule I substance. That on January 4th, 2024, the defendant was arrested with hashish in the amount of 441.34 grams of Schedule I substance in his vehicle. He was there at that arrest with the intent to sell that solid hashish And then a search warrant was conducted on his residence, also on January 4th of 2024. And in his home was located marijuana with all of the tools necessary to sell that marijuana. There were also 3 firearms located in his home at the time of the search warrant, along with all of those drugs, as well as $7,421. The buys and the arrest all occurred in Warren County, and the search warrant was a part of his continuing course of conduct.
All right. Mr. Mulligan, anything on those facts?
No, Your Honor.
Mr. Brown, did you hear the statement that she read?
Yes, Your Honor.
Do you admit and acknowledge what she said is true?
Yes, sir.
And again, you understand all the rights you're giving up entering a plea of guilty, those rights we just discussed.
Yes, sir.
And what is your plea?
Guilty.
The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed, and the court will accept your plea of guilty. And based upon the statement of facts in your plea, the court will make a finding of guilty. It's my intention to proceed directly with sentencing right now. Ms. Nicholson, anything on behalf of the state?
Your Honor, nothing in addition to the agreed sentence. We would ask that the court sentence the defendant to 12 months on the counts to which he pled, 12 months on the firearm specification, for a total of 24 months in prison. We would ask for a $1,410 lab testing reimbursement to be ordered to the Warren County Drug Task Force, and that the court, based on the defendant's agreement to forfeit the 3 firearms mentioned in the plea form, that those be released to the Warren County Drug Task Force to be disposed of pursuant to law, and that the court order the forfeiture of the $7,421.
Do you have a jail time credit?
He has 0 days of jail time credit.
Mr. Mulligan?
Your Honor, first, we would ask that the court impose the recommended sentence. This has been a learning experience for Mr. Brown. I honestly do not expect him to be back before another court based on what he has dealt with. He has shown the ability in the past to be employed, and I would anticipate that he would regain that employment once released.
Thank you, Mr.
Maybe
Brown.
not
Is there
with
any-
the same employer, but I expect he will have a job.
Okay. Mr. Brown, is there anything you'd like to say before I sentence you?
No, Your Honor.
Mr. Mulligan, do you have an affidavit of indigency?
I thought that we did, Your Honor.
Let me look, I have it up now, hang on 1 second.
Yeah, we filled one out.
Yeah, we did previously fill one out, and I believe it was filed as well.
Yeah.
But it was some time ago when that
All right, let me go back on the docket and make sure.
happened.
I'm looking as well. I don't know that I see it filed.
Probably been around November
November?
or December.
I do not see an affidavit. I do not see, oh, wait a minute. No,
I don't see one in benchmark.
I don't see one, Mr. Mulligan.
I'd be disappointed if it was still in our office. I can inquire of my staff whether it was filled out, but I know that we physically filled it out.
Yeah, because I came in and filled it out.
Right.
I think it was around like 5 p.m.
We can fill out the form again here if the court would give us a minute or two.
Okay.
On hold.
Yeah, because you're not working. That would go.
Did you get lunch?
I'll make it.
What's the total load, do you know?
About 15,000.
Deputy Cressup's here too.
And I have other two.
So I don't have to worry about,
Chances are
I don't have to worry about the food going to waste, right?
As of today, Your Honor, he is, of course, not employed. He's reporting no assets and has debts on automobiles that would, are significant, and he has about $15,000 in credit card debt. And he's filled out the form. I can notarize it.
Okay.
Thank you. Appreciate it.
All right, again, Mr. Brown, is there anything else you'd like to say?
No, Your Honor.
All right, the court has considered the statements made here today, the purposes and the principles of sentencing, the relevance, seriousness, and recidivism factors. The court has also considered the agreed recommended sentence of the parties and finds it to be an appropriate sentence. So on count one, you're ordered to serve 12 months in prison. On count 3, 5, 6, 10, and 11, you were ordered to serve 12 months in prison on each of those counts, and each of those to be served concurrent with count 1. You're also on the count 10 firearm specification, ordered to serve 12 months in prison, and that is by law ordered to serve prior to and consecutive to the 12 months in count 1, which leaves a total sentence of 24 months in prison. The court is ordering the forfeiture of the firearms as listed in the plea agreement and the forfeiture of the $7,421. There's 0 days jail time credit as of today. The court having found the defendant indigent for the purpose of any fines, costs, or other financial sanctions, including the mandatory fine as outlined in the plea agreement. Now, you are also subject to a discretionary period of post-release control, which I spoke about a moment ago. Do you need me to go over that with you again?
No, Your Honor.
All right. There may be opportunities for you to receive up to 1 day per month for participating in certain education, vocation, or other programs sponsored by the Department of Corrections. You do have a right to appeal the court's decision if you're sentenced to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost. If you cannot afford an attorney, I will appoint one for you at no cost. Ms. Nicholson, is there anything else?
I don't believe so, no,
Mr.
Your Honor.
Mulligan?
Thank you.
All right, at this time,
For setting it over.
Okay.
I appreciate it. He
All right.
appreciates it.
all right, at this time, you are remanded into the custody of the Warren County Sheriff for transport to the Department of Corrections.
Okay.
All right,
Thank
thank you.
you,
Yeah, denied. He's not eligible.
No,
Yeah,